We can take up the Couch matter.
Thank you, Your Honor. And the first thing I just want to bring to the court's attention, I understand Kurt, who is also present in the court, was recently appointed as Mr. Couch's counsel. But as I brought to his attention yesterday, there appears to be a conflict of interest. My client consulted with him back on January 19th, 2018.
Yes, Your Honor. I received counsel's indication of a potential conflict. I don't believe I have a conflict. I looked at the rule, RCW, or not RCW, RPC 1.9, and it's pretty clear that it requires formally represented a client in a matter similar to this, and I never formally would have represented Ms. Couch. I have no independent recollection. I have no documents. We searched the office for a conflict and couldn't find any. All that being said, Ms. Couch is saying that we had a conference, 5 years ago. I leave it up to the court if you want to remove me from the case and appoint somebody else. But we've filed a declaration, and I would at least like to represent the client with regards to today's hearing.
And Your Honor, we're fine with him representing Mr. Couch insofar as today's hearing. And I do understand that he already submitted pleadings, but the reality is he did give my client legal advice. He did ask her perspective and some rather personal questions about her position with respect to the pending dissolution. And it is my understanding that if an attorney intends to keep open the opportunity to represent the opposing party, they have to get informed consent from the party they are consulting with. My client did not give any such informed consent and feels uncomfortable with him continuing to represent Mr. Couch.
All right.
Are you looking at RPC 1.9, Your Honor?
But I'm looking. Good.
Yeah. RPC 1.9, if you look at the comment section under section 3, it says information acquired in prior representation may have been rendered obsolete by the passage of time. On the other hand, knowledge of specific facts gained in a prior representation that are relevant to the matter in question ordinarily will preclude such representation. I don't have any knowledge, but there has been a significant passage of time. But again, all that said, if the court, my understanding is the court has been struggling to find representation for Mr. Couch, and if you want to remove me and appoint somebody else, that's fine. I'm busy, so that's okay with me.
Well, and as we said, just to avoid further delay, we're fine moving forward with today's hearing, but ordinarily the next step is really to proceed with trial. And so if there's going to be a delay in any case in setting a trial date, then we would just ask that he be appointed new counsel for that.
All right. I'm looking at 1.9, and a lawyer who's formally represented a client in a matter, and you're saying you haven't represented this person, although apparently she consulted with you?
Apparently she indicates she consulted with me. I've checked my records and we couldn't find any records of that. Yeah, I'm looking at 149 as formally represented. I don't believe I've ever done that. I don't believe I ever, there would have been a notice of appearance in this action. I'm not sure if this action, even how old this action is. I don't think it's that old.
There was a previous dissolution filed prior to the current one, and that was the subject of the previous consultation. So during that consultation, my client did give information that is material to the matter at hand. And again, did not give informed consent for him to later represent Mr. Couch. But again, we have been before the court for about 3 months on this motion and are ready to have some resolution. So that's certainly something we can table for later. I just wanted to bring it to the attention of the court, but we're happy to move forward for today's purposes to resolve the matter at hand.
All right. Well, my concern is the court has appointed Mr. Anagnostou, and what I'm hearing, and it's disputed, is that the argument is he's representing a person in a substantially related matter in which that person's interest or material is adverse to the former client, and that the former client is not given informed consent in writing. Given that the court has a hand in this, I think that the safest route is to find new counsel. And I realize that's not ideal for anybody. But if Mr. Anagnostou has a conflict, he has a conflict today, and he has a duty to his former client today, just like he would a week from now on something else. So I don't think just an agreement to have him hear the matter changes whether or not he's got that duty. And because the court appointed him, and there's a question about that, I don't feel comfortable going forward because of the court's hand in it. But what Mr. Anagnostou says is he doesn't have a recollection of it or a record of it. And it's possible that he didn't meet with her. So I think we need to resolve that matter if it's his position that or I just need to appoint new counsel. I think it's probably cleanest just to appoint new counsel. And I don't know that that's going to happen anytime soon. In terms of the motion today, I've read Mr. Anagnostou's pleadings, Mr. Couch's response. And is the trustee here, or the attorney for the trustee?
The attorney for the trustee is not present. He did appear previously at a different hearing, and it was the instruction of Judge Fassett that any type of new contracts that were being entered into for the property were to be approved by the trustee, because what's happening right now is Mr. Couch is further encumbering the property in a sense by entering into new business contracts and leases without having first cured the default. So the issue here is really that the cart is being put before the horse. I did read in the pleadings that he intends to cure the default in the next week. And if that's the case, I mean, we would happily dismiss the motion, right? The issue for us is that we do not want it to go into foreclosure. So one thing that I was going to propose today is that we set it over a week, that if he has in fact cured the default, then the motion can go away. We would voluntarily dismiss it, in fact. But if we come back in a week and he has not cured the default, as he's indicated that he will, that the court grant our relief and set aside these leases that he's been entering into while this motion is pending, because the trustee has not authorized them. And as I said, he's only further encumbering the property and making it more difficult to address if he is unable to cure that default.
Okay. I was thinking of potentially having him put the money to cure the default in trust and see what happened with the lease agreement. But I think putting it over a week effectively does the same thing. And if it's taken care of, it'll be taken care of, and that it sounds like that's fine with your client. So I will set the matter over 1 week, and we'll see where we are. Mr. Anagnostou, I am going to relieve you. We'll look for different counsel for Mr. Is it Couch?
Right. I'll present a order of discharge.
All right.
yeah, to discharge me from his representation, it's required that it be by order. So,
And that's fine. I'll sign that order upon presentation.
And Your Honor, will you be on the docket next week, or will it be Judge Fassett? I just want to know.
Anticipate it'll be Judge Fassett. I just am here for her this week, and this is usually her docket. But I'll communicate with her as to what happened here today.
Okay. Does Your Honor want anything reduced to writing just with regard to curing the deficit? And the intent in setting it over a week to cure that default?
Well, either the trustee's going to be, they're going to have their money and they're going to be okay. Or, I mean, if they make that representation to you, it's your motion. I don't know that we need anything necessarily reduced to writing as long as you're satisfied that the default's been cured and that the current situation with the property is acceptable.
Okay. Well, I'll just state for clarity, I just want to make it clear to Mr. Couch that if he does in fact cure the default and provide us documentation that he has cured the default, we'll happily dismiss the motion. But if he has not cured the default before we appear next week, we will be asking for relief and add to the order that we would ask that any leases he's entered into be set aside, which, as I recall, was also the request of the trustee when they appeared previously for any new leases that were not authorized.
So my understanding of where we're at, Your Honor, is Judge Fassett asked for him to provide a plan for getting the property out of default. And that's what he has done. He's provided a plan. And I believe
in terms of that, counsel, I'm just going to, Judge Fassett will be on the docket next week. And we're getting so close to November that I think we need more than just a plan. We need to actually have this dealt with so that so that we can move forward and that the arrearages can be taken care of.
Right.
015-08. We're here on the I believe it's the fourth review of the motion to compel answers to discovery to interrogatories.
Is Miss Erickson present? Is Brittany Erickson present?
And just so Your Honor's aware, interrogatories were served on January 12th, quite a long time ago. We had a CR26I on March 6th. Still, we didn't have compliance. We filed a motion to compel back in March of 2023. Hearing was held April 18th. She was given 3 weeks to comply. She didn't. Attorney fees were given. We had a review on May 9th. Still 117 days had passed, still no answers. We had that review March 9th. She was given an additional 14 days and told that if she did not answer, that she would have, her pleadings would be stricken. She was given a protective order just for her address. She was given till May 23rd for that striking her pleadings from the record. She did not answer. They were stricken on the June 6th compliance order. This is, again, we did another CR26I conference on June 2nd. She did not attend. She did have new counsel as of June. We did another notice to them. We showed them what the deficient responses were. We sent another motion to compel. It's been 265 days. She's not materially answered. We'd ask for her to be defaulted. The court has tried everything: attorney fees, striking from the record, not able to give testimony, additional time. It's been almost a year. She shows up, she doesn't show up. Her counsel shows up. She had counsel for months, and we tried to get discovery and we were unsuccessful.
One of the things that I guess I'm concerned about is that I look at the declaration in support of the initial motion to compel back in March, and I realize that other judicial officers have ruled on this, but I'm being asked to find somebody in default. And I see respondent failed to answer said discovery and a 26I conference was scheduled. Said date has passed and respondent has failed to attend scheduled CR26 conference. There's a notice in the file about that. And I don't think that
we did have a conference. We've had 3 CR26Is where she's not made it to 2 of them. One of them we did have, that's where she asked for the protective order. That was before the May 9th hearing. We agreed to protective order. We came to court, we agreed in court for the protective order. She was given 2 additional weeks to get that back and she failed. So we have had a CR26I again, when she was with counsel, we did discuss discovery. We were also told that we'd have it back. We sent them out a deficiency letter and again, nothing. So the first one, we sent a notice of CR26I. The remainder of those we scheduled. And I have talked to Ms. Erickson. I have talked to her former counsel, Scott Roberts, but nothing ever comes of it.
So you actually had a CR26 conference?
Yes, we had a CR26I, and I believe it's in the declaration or it's in the order on this hearing. Bear with me. So she missed the May 24th, but she attended the earlier one.
The other thing is, that was my first concern. I'm also concerned that she's answered the interrogatories at this point, maybe not entirely to your liking.
They're materially deficient. We can't put on a trial. We don't know. She was given a protective order so that I could have the information, but we know nothing about the child's doctors, the child's school, daycare, her drug and alcohol history, her address. Most of those things are missing. Her income, I don't believe she's working, but I'm completely unsure. We did send out the notice. I have spoken to her.
I'm comfortable limiting her to her answers, but I'm not comfortable with the default at this point.
Okay. My concern is that I'm limiting her answers. My concern is she's not even going to show up for the trial. Your Honor, is there anything I can do to make Your Honor comfortable? Set this out 2 weeks, and because we already have her pleading stricken. Set this out 2 weeks and do whatever necessary in order to I just want the discovery, to be honest with you, because even if she's defaulted, it doesn't change that I have no idea any of the circumstances of this child's life or hers. I'd be more than willing to set this out, serve her again with it, serve her with a notice of CR26I, give her the deficiency letter because she has received that through counsel. Outlining exactly which questions she needs to answer. I'd rather have that than limiting her answers, to be honest with you.
Your Honor, this is GAL. I also had the same problems getting I've gotten nothing from her I needed except for the limited things in the report. Her attorney reached out to me asking me, and I gave him what I had. He goes, and it wasn't what he needed. So I also have the same problem.
Yeah, I think, at least for me, I think I would need probably a deficiency, a more specific deficiency letter because I've got a large exhibit here, and I have to guess or make my own judgment as to what's sufficient and what's not. And it's a pretty extensive document.
Is Exhibit E of the motion, is that not sufficient enough? That was given to her counsel. It lays out exactly which ones are deficient and what she's failed to answer. And that was provided on August 7th. I can also maybe make a table showing the question and the.
That's fine. Let me look at it again.
Okay. And just so your honor's aware, that was me paring down, taking out at least 50% of the questions that she hadn't answered and just getting to the things I absolutely had to have for trial. The original letter, I believe, is at C or D. It's considerably longer.
So you're proposing sending another deficiency letter and coming back in a couple of weeks? Is that?
Yes. Yeah, at this point, her pleadings have already been stricken. There's nothing she can do at a trial. But really, we still need the information, you know, to make a parenting plan, even if she's completely out of the picture, aside from a default where I just, you know, assume things. We need the information. So I would ask that we come back. I'll send her another deficiency letter. I'll outline exactly what needs to be answered. If your honor can give me a drop dead date on a date where I tell her you will be defaulted if it's not, you know, received by such and such date, I would be more than happy to do that.
All right. October 31, I think gives her plenty of time.
And I will email her, mail her, and I'll provide proof of service of the same to the court much earlier than that date.
All right.
All right. Thank you, Your Honor.
Thank you. And Mr. Wanzer, I see you're here. If you could unmute. Okay. I've read both counsel and Mr. Wanzer's pleadings, and what I'd like to do is I'd like to just have you guys get your calendars so we can set up a 26I conference to deal with both Mr. Wanzer's concerns about discovery and Mr. Anagnostu's concerns about discovery.
Yeah.
That's what I've been trying to accomplish, Your Honor. But so,
and that's where I think that's.
I have made several attempts.
Okay, wait a minute. What I need is your calendar, and so I'm wondering. I mean, I'm thinking the sooner the better. Is there any time this week that either of you would be available? And I understand Mr. Wanzer is more available after late afternoon. Correct me if I'm wrong about that.
Yes, I'd have to come in from work early. I work in the woods, so I'm always a long ways out. So I got to try to plan for that. I've been taking a lot of time off to do this stuff. And
I mean, can you guys meet later today, later this afternoon?
How about Friday?
Friday works for me, Your Honor.
Okay, and what time can you both make it?
It'd have to be an afternoon. I mean, I'd have to try to get in early again to try to make this happen. So it'd have to be around 4:30.
I can make that work.
Okay, Friday at 4:30. So that's October 6th at 4:30. And then we'll set this for review on the 24th.
I will be gone. I have a thing of eligibility that I will be gone from October.
All right. What about the 31st? Will you be back then?
Of October, yes.
All right, I'll set it for review then. And hopefully the parties can work out the discovery issues between now and then, but we'll set that 26I conference for October 6th at 4:30.
Mr. Wanzer will call me.
Yeah, he's the moving party here, so he'll call you.
Yes,
Perfect.
I will call him at 4:30 on Friday. Yes.
Perfect.
All right. I see a couple pleadings in the file, and there's a motion for reconsideration that Judge Fassett needs to address, and those motions I generally are just determined on pleadings alone. So, and then I see a motion to bifurcate the proceeding. Is there anything else I need to address today?
That's it.
I think that's it, Judge.
Okay. So, Mr. Hitchcock, this is your motion. Go ahead. If there's anything you want to say besides what you submitted.
Just that this relationship has grown toxic, unfortunately, and it continues to do that, become more toxic and more bitter. And a bifurcation would be in the best interest of both parties for their mental health. There's a number of things that we won't get into now, but like there's just incredible bitterness from, and hurt on both sides. And Megan's continued to do things and that have hurt me, and I've continued, she's been hurt, and it would be very good for me to have this marriage legally ended. We've been separated for over 3 years. And every step has been a fight. I don't know why this step has been a fight. I'm just asking that we legally dissolve the marriage, as this going to trial will take another year from what I understand. And there's animosity being attached to this woman who continues to do things that hurt me, and she feels hurt. She recently, a few months ago, from our old church over the pulpit, said that she was in an abusive relationship, meaning with me. But we haven't.
Your Honor, to object to anything that's not before the court.
This has been reported to me, and we're not in a relationship. The fact that she uses me to say she's in an abusive relationship, I've never been abusive to her, and I want to bifurcate this divorce. I want it to be legally ended, and I don't understand. I really believe the opposing party lawyer is drumming up business for himself. Megan's got to be spending over $600 for this, for no real reason. How does she have it both ways? She hates me and I'm so horrible, and she doesn't want to bifurcate the divorce.
All right. Thank you. Mr. Zandy, any response?
Yeah, I guess I'll start with the obvious. As far as drumming up business, that's the last thing I need to do. I think the family law attorneys in the local area are beyond overworked, and there's a lot of business to go about. And certainly this case is not necessarily one that has a gold mine at the end of it. We're doing this because, unfortunately, we're here on, again, actions of Mr. Hitchcock, which continue to abuse the court system. And we're here on a motion to bifurcate, and there's no legal or factual basis to do that. I would certainly wager to say that anybody going through a dissolution action would love to bifurcate their divorce and just simply be resolved after 90 days, but that's not the reality, and that's not what the law sets forth. We have given you the basis for bifurcating cases and divorces, which states it's generally, and that's the little case, that it's generally disfavored, absent some agreement and factors which would warrant said request. That's done when there is a certain agreements on material aspects of the case and not on others. That certainly doesn't qualify here. This is one where Your Honor has not heard the majority of the motions that have been brought by Mr. Hitchcock, but he was warned last spring after he filed a motion to compel without requesting discovery or conducting a CR 26I conference. He has later filed motions to set aside restraining orders. He has generally lacked and then grasped understanding of how this process works, but unfortunately that has not stopped him from filing frivolous motions. And this is, again, just the latest
objection. It was never said that those were frivolous motions.
The argument is this one is. The argument would be that this needs to fall under that category because, again, pursuant to that, there is no legal basis and there's no factual basis. If the court was to grant his order, which essentially says the case is bifurcated, the parties are divorced, there's implications on that for taxes, property, debt, parenting plans, there's insurance inquiries that go into that. And if the court just says, okay, you're divorced without a decree doing that and finding the marriage irretrievably broken, that would be in significant error and would potentially jeopardize both sides' rights under insurance, taxes, and the like. In my review of Mr. Hitchcock's declaration, it looks like the sole reason he wants to bifurcate the case is so that he can date, quote, Christian women. Again, that hasn't stopped him in the past. We've provided you information from some of his pursuits in which we have no idea who they are, but they reach out and send my client random notes that say, hey, I'm glad there's a restraining order. This guy is outside of his essential mind. And again,
objection, that's not what was said.
Random, that was spontaneous and sent to my client. We filed that previously. And again, I'm paraphrasing, but that was the gist of it. And to suggest that I want to be legally divorced for no other reason so I can date other women is unfounded, and it's not supported by law.
Objection, that's
but
the
also
12th thing I said.
All right. Mr. Hitchcock, I understand you may not agree with this. I'm going to hear the argument.
Yeah, and I'm just saying that I object that he said that the main reason I wanted was to...
Noted. And go ahead, Mr. Zandy. Anything else?
Yeah, so if you look at the basis again for a bifurcation motion, this doesn't quantify or qualify under that. And this is an individual who unfortunately has been sitting here patiently for 15 months, who was ordered to undergo a mental health evaluation, and we still have nothing related to that. I've sent requests. I provided those to you as part of my exhibits to my client's declaration, which show, despite multiple requests, multiple inquiries from the court, we have nothing related to his mental health evaluation that was ordered nearly 15 months ago. That's unfortunately been the hang up on this. To grant a motion to divorce these people when there's material issues that still have to be resolved, which are directly impacted by that order, just for the sole purpose of Mr. Hitchcock going out on and pursuing his Tinder dates or whatever it is he plans on doing, again, is
objection
in error would be in error. So that's my argument. We are asking that you find a CR 11 sanction. Again, it seems extremely frivolous. My client has paid money, and again, unfortunately, her fees are the direct result of Mr. Hitchcock continuing to file motions such as these. So we do believe that a strong message should be sent. And I think the only way to do that is through financial recourse. The court has imposed, by my count, up to about $3,500 in total fees that he was ordered to pay in the past. And to date, he just hasn't done it. We're also asking that you set a date certain for him to pay his fees, and also require an order that says the court should review and approve any proposed motion that he wishes to file. We now have this motion, which is pending, and we have a motion to reconsider, which is pending, which is ironically related to tax issues, which are directly impacted by a bifurcation motion. So again, if you look at it logistically, it makes zero sense, and it's due by design of Mr. Hitchcock, and it's abusive litigation. I mean, that's the only way you can really detail that, and it absolutely needs to stop. And we're asking the court to, again, enforce its prior ruling from the spring in which it said this isn't going to be tolerated any further.
Your Honor, I don't believe most of what Mr. Zandy is stating. So he's arguing that Megan wants to stay married, so we file taxes together. That's not a reason to stay married. That's not a reason to put us through the mental anguish of being legally connected to someone who hates, maligns, badmouths. Once again, I mean, we're talking so, and Washington does allow bifurcation. All the states do. Washington doesn't as much, but it does allow bifurcation. This isn't a frivolous motion. This is a legal motion that I set forth, and I'm surprised that they brought it to court. I thought it was going to be signed. Once again, I think the main thing that Mr. Zandy is saying is that there's potential money things. Like, even if we weren't married, if we had never been married, there still would be the same laws in place. I'm not asking for anything other than to be divorced, because it's bad for my mental health, and I don't believe it's good for Megan's. Once again, she's saying like, oh, I'm in this horrible marriage. Like, you're not in a marriage. We've been separated for 3 years. And I find the Tinder date thing offensive. And once again, he said that it's been argued that the main reason is to date other people, but But that's the 12th thing I've listed on the list. I mean, Megan has a 6-page declaration and I have 13 bullet points. I'm just asking to be divorced from this woman. That's it.
All right. Bifurcation is not a process or a procedure that's favored in Washington.
It is under toxic situations, though.
Hey, wait a minute. You're done talking. I gave you plenty of chance to talk already. So at this point, bifurcation is not favored in Washington. I don't see a benefit. And it has a lot of potential consequences that Mr. Hitchcock, I think, frankly, you just probably don't appreciate. And if you're representing yourself, you end up being held to the same standard as an attorney, which admittedly is a tough thing, I think, sometimes for pro se litigants, but there has been in review of the file, just a number of motions that seem to be without basis. This is a motion that I don't see as having really any basis, legally or factually. I am going to impose $500 in legal fees payable to the office of Chad Zandy. Those fees need to be paid by December 1st. In terms of any order regarding Mr. Hitchcock and filing motions, I guess, is that just a request you're making here? Because I didn't see that in your pleadings.
No, I think if you look at the last page of my client's declaration, it was there. That's on page 5, line 13 through 15. I would also ask the court to require Mr. Hitchcock to have any motions filed on his behalf reviewed and approved by the court prior to filing and serving those. And then my client details the significant resources she spent responding to motions such as this. And it's gotten really bad since late last winter. And now obviously here we are on another kick of bifurcation motions and motions to reconsider and such that, frankly, my opinion, I don't see a lot of legal merit to. And I just want to avoid that if we can. And I think this is the only way to curb that. I realize that it's kind of an extreme measure, but I think we've broached that point. And I think that's really the only way to curtail some of the abuses.
I'm looking at the declaration that was filed October 2nd.
That's the motion to reconsider, Judge. This one was filed on September 22nd. So the one you're referencing on October 2nd was filed in for the motion to reconsider, which should be in front of Judge Fassett. He's asking the court to reconsider her decision from a month and a half ago or so.
That's legal.
I'm going to enter a separate order that does require the court to approve.
Your Honor, can I speak?
No, not until I'm done with this. All right. Any motion that Mr. Hitchcock wants to file needs to be sent to Superior Court Admin at Cowlitz.gov, excuse me. And I'm going to need to revise this, so I'm going to rewrite this, but the court will review the pleading and determine that it's not frivolous prior to the document being filed and served. So, Mr. Hitchcock, what that means is you're going to need to email anything you want to file with the court to that email address. A judge will review it and determine whether it's appropriate to move forward, whether there's a colorable argument or a valid argument that's being made. And, in these situations, the court will probably err on the side of allowing you to file the document, but there needs to be, at this point, there's been enough what appears to me to be frivolous litigation that the court needs to, and fees, the imposition of a number of fees have done nothing to change that. So this is an extreme remedy, but I think in this situation it is justified. I'm going to enter an order that's substantively what I just announced. I just need to rewrite it and give it a little more thought before I actually finalize it. That should be an odyssey within the next day.
And you said I could speak, but I did talk to Judge Fassett about this in Megan's previous motion, and it was said that I would have to bring it forth in an actual motion, which I did, which is what she said I would have to do.
Okay. And I don't think this is inconsistent with that. I'm just taking it an extra step now that I've reviewed this, the motion that you filed. She didn't have the motion in front of her, but now that I've reviewed it and reviewed the response, I think this is appropriate given the overall context of the case. So that'll be the order of the. So I'm going to be entering two orders. One order that imposes $500 in legal fees to the office of Mr. Zandy, payable by 12/1/23, and the other order requiring you to file any pleadings or have any pleadings reviewed by sending them by email to the court before they're filed.
In the first order, Judge, are you, I'm assuming, specifying that the order to bifurcate is denied and is frivolous? Yes. Okay.
It starts out, Mr. Hitchcock's motion for bifurcation is denied.
Okay, thank you. And I don't know if we were going to hear from Ms. Height or not. Somebody asked something, maybe that was on Mr. Hitchcock's end.
No.
Ms. Height, do you have any information you thought was germane to this?
I do not, Your Honor. Thank you.
All right. Thank you.
Thank you.